Hello, everyone. My name is Ismail Shakhtakhtinsky. I'm the principal immigration attorney at I.S.Law Firm. Thank you for joining us our live stream, weekly live stream on U.S. immigration laws. I will, in this live stream, answer as many questions as I can, which you can post in the chat section. Please also like this video and please subscribe to our channel so you can be informed of important videos and instructions and immigration news that we post on our channel. So today is June 8th, 2023. I hope everyone who is in Northeast United States is safe and indoors. As you all know, there were wildfires in Canada and there is polluted air warning currently in Northeast, in New York, Virginia, Northern Virginia, Pennsylvania, and most of the northeastern United States. Again, my name is Ismail Shakhtakhtinsky, and I'm the principal immigration attorney. This is our weekly live stream. In our YouTube channel, we post videos and instructions and immigration news. If you subscribe to our channel, you will receive notifications. And in these weekly live streams, I try my best to answer as many immigration questions as possible. I'm the principal immigration attorney at I.S.Law Firm, and we are a law firm practicing immigration law in Virginia, near Washington, D.C. We handle all types of immigration cases. There is a contact information in the chat section. It will be also underneath this video and also in the comment section. If you would like to schedule a one-on-one consultation with me, you can click and you can schedule a consultation directly in my calendar. You will be entering your information, you'll process the payment for consultation, and you can select and block the day and time. Now, using this opportunity of live stream, you can also post any questions you have in the chat section. All of the information is kept confidential on our end. Obviously, if you post a question in the chat section, that's visible to the live viewers. Again, thank you so much for joining us. Now, today, I wanted to briefly talk to you about investment-based visa E2, which is a type of visa for investors in small business in the United States. I will briefly give you a summary of what E2 investment-based visa is, how it works, and then answer as many questions as I can in the chat section. It doesn't have to be necessarily, the questions don't have to be related to the subject of this video. It doesn't have to be related to the investment-based visa. As you all know, our primary focus in immigration practice area is on humanitarian, in asylum cases. We do handle a significant number of cases for asylees who arrive at the southern border using CBP1 app, which is available, which makes the transition very smooth, the entry into the United States very smooth and orderly without detention. So you can post any questions you have about asylum case or any other immigration cases that you may have or you may want to know about. So what is E2 visa? E2 investor visa is a type of visa issued for citizens of countries which have E2 treaty with the United States, based on which the investor and the family of the investor can immigrate to the United States, live in the US indefinitely, updating and renewing that visa indefinitely every 2 years to manage their own small business. The spouse of the E2 visa holder is eligible for employment, and the children can go to public schools in the United States. As I said, the applicant or the spouse of the applicant have to be citizen of E2 countries, and that means a country that is a party to a bilateral agreement with the United States on E2 visas, on the small business investment visas. You can find the list of those countries in the State Department's website. If you just Google E2 countries, you will see if your country is one of them. And if it is, then as long as you open a small business in the United States, you invest substantial amount of money, which is what the law says. Typically, it's interpreted anywhere between $75,000 to $100,000. And in reality, if you open a small business in the US, which is an active business, then that would be the minimum amount you're going to spend anyways for the business. And the money you spend, anything you do for the business counts towards that amount, required amount, which is again between anywhere 75 to 100 or more. And the reason it's gray how much money you have to spend for the businesses to qualify for E2 is because the law says substantial amount, but the way the USCIS or the State Department interprets it is, depends on the size and the type of business, and typically around 75,000 or more, we do qualify our clients and they do successfully obtain E2 visas. If you obtain E2 visa for you and your family, you can also bring employees from your country, as long as the employees are citizens of your country that have specialized knowledge in the type of business you have. And that's also subject which can take a lot of time to discuss what specialized knowledge means. But as I said, maybe we can make a separate video on this, but I'm not going to go into this now. But as long as they have specialized knowledge, or you're bringing a manager, a managerial employee. We frequently work with clients on bringing employees from their countries. Just yesterday, I think it was yesterday, we got a client, a manager employee for E2 business who was approved at the U.S. consulate. Now he and his family are coming to the United States. They'll be managing a restaurant. So again, this is not a principal E2 applicant. That's not the owner of the business, but that's an employee of the business. So what are the main requirements for E2 is, as I said, you need to spend money for the business, around 75,000 or more. You need to demonstrate the source of the income, of the money, where you got the funds to spend for your business. Then you have to actually spend the money for the business, and you have to demonstrate, with the showing invoices, receipts, any kind of bills you paid, canceled checks, wire transfers, and so on. And you have to demonstrate that you're coming to the United States to manage that business. The business has to be an active business, not passive. For example, you cannot buy a house or apartment and rent it out and say, this is my business. Yes, in the business world, it may qualify as a business, but it's not an active business. The easy test to do is to ask yourself, will my business grow? Will it have employees? Am I planning to have employees, for that business? If you're buying a house or apartment and renting it out, that business is not going to have employees unless you hire, let's say you buy an apartment complex and you have a management company, you hire an engineer, a property manager, cleaners, whatever you may hire, that might qualify. Or you buy a hotel, or you rent a space and open a hotel, then that can qualify. But just a passive business where you invest in a business and you're standing aside, there is not much you're doing in terms of management, and there is no progressive business plan to grow it, that may not qualify for E2. Again, E2 is a very beneficial type of visa. You don't have to demonstrate any close ties to your home country if you're applying for E2 visa. The consulates have very limited discretion, contrary to, for example, if compared to a visitor visa or a student visa, which is, traditionally everybody knows that the consular officers have very wide discretion in being able to deny those. They don't have that much of a discretion in denying E2 visas. So as long as you do everything right, as long as you have a bona fide, good faith business that you created and you're coming to the United States with your family, you're moving to the US to manage that business, your E2 will be approved, again, as long as you meet all of the requirements. And we are here to help. If you want to create a business in the US, you don't even have to be in the United States. We can register your business. We can help you open your bank accounts. We can help you, do with any employee contracts, buy existing business, or buy assets, or, prepare agreements, employment agreements, lease agreements, and so on. We can take care of all the business side. Again, you don't have to be in the United States do that, to start that. Then we can also do the immigration portion of the case by preparing forms and documents, applying for you and your family's E2 visas, and guide you and prepare you for the consular interview to secure E2 visa for you. You don't have to be, the client doesn't have to be in the US. Now, typically what happens with E2 businesses is a lot of immigrants, they either have a relative or friend in the United States who's going to be initial manager, who helps them with the business side of things. Again, we can help with the business legal side of things, such as, preparing agreements, documents, and so on, registering your business. But you do need someone. You need to either hire someone in the US, or you can have a friend or relative in the US who's going to help you with establishing the business, with logistics of the business at the initial stage, until you and your family obtain E2 visa and come to the United States. So that's E2 visa in a nutshell. It helps a lot. A lot of times people want to, spend $1 million and hire 10 employees to qualify for green card, or they want to apply for a strenuous and very difficult type of visa, which is L1, intra-company transferee visa, or they want to do something else in the US. We always advise them, hey, if you open a small business, start with small, get E2, come to the US. So you are now here in the US, you got your foot in the door, and then now you can continue growing your business. And if you reach to the levels of $1 million and 10 employees, then you can file for permanent residency. There is no reason to wait and just file straight for permanent residency. You can start with E2, and then there is a lot of different options for getting permanent residency for you and your family. Okay, so this is the E2 visa in a nutshell. Now I will move into answering as many questions as I can. Again, thank you for those who just joined. Thank you for joining our live stream. Please post your questions in the chat section. Please also subscribe to our channel and press like. All right, so I'll start first with the questions from audience, and then I will move on to questions posted by our admin. For some reason, there is a glitch. I don't see all of the questions on the top. But anyway, so let me start with first question I see from audience. Melissa asks, when did you apply and when did you get the biometric? Well, I think it's just a glitch in the YouTube. It doesn't show me the beginning of this question. Melissa, if you can repost that top question you had. Let's see, live chat. Okay, there is a unpinned message. Okay, now I can see. Yeah, there is a pinned message which was blocking everything. All right, so the first question I actually see is from Bkderos Piou. Hello, thanks for helping us. I applied for asylum but did not send my statement yet. I'm waiting for my interview date. What will be the best time for me to send my statement, please? Well, the best time to send your statement and supporting documentation and country conditions evidence is as soon as possible. Ideally, as I explain in all my videos, you should do it, and it's very important to do it all at once. In the beginning, when you file your asylum application, you want to have your complete package. It's a human factor, and I don't say it just because I have some secret that I know you don't know. I try to explain it, break it down for you, why it's important. Number one, it's a human factor, right? So there is an officer who's sitting at the asylum office who's going to receive your package of documents, review it, and they will see that when you filed, you didn't file your statement, right? So you didn't file supporting documentation. You just filed the bare bones application just to get your clock started. That creates an impression in that officer that maybe you didn't have really basis for asylum. Maybe you did it just to simply to get by and to be lawfully present in the US. And if that's the case, the damage is done, and it's hard to turn that idea, that thought in the mind, turn around that thought in the officer's mind. So it's extremely important for everyone who is planning to file for asylum to file a complete package in the beginning, from the beginning. Now, what happens if you already filed because you listened to bad advice and filed your asylum application without your statement and documents, as this member of our audience is asking? So you can supplement, do supplement it. You have a right to supplement. You can supplement it before the interview, but the sooner the better. Don't wait for the interview. Now, the second reason, by the way, you should file this now or at the time of filing initially is because then your interview is going to be faster, probably. Okay, the reason I say probably is because asylum office is chaotic, they're backlogged, but that's also a human factor. So when they see a case that is complete, that everything is filed, that everything is ready for the interview, then the asylum office, considering the backlog they have, is motivated to review your case faster. Now, sometimes when they see a case that is not complete or has significant defects, which typically missing a declaration, I would say, is a significant defect, missing a statement, asylum case story is a defect, then they may actually also schedule an interview much faster because they just want to get rid of the case. But again, you don't want to try that because that damages your case, because they do annotate in the case that this case is missing declaration or it's past the deadline and so on. So instead of waiting for years, they just want to clear it up, and they don't want to encourage people filing frivolous or baseless asylum cases just to get by, to get a work permit and so on. So that's what's going on in their mind, and that's why it's important to file in the beginning everything. And if not, then if you already listened to bad advice and filed without a statement, do it now. Gather all the documents, gather all the evidence, country reports, country condition reports, and file the entire package properly typed, tabbed, paginated, with table of contents, well organized, so that your chances for approval will significantly increase if you do that. You have to understand that the officers are overwhelmed. They have a lot of cases. If you don't properly organize, paginate with table of contents, you don't file all the necessary reports, that significantly reduces the chances of your approval. They're not perfect. The officer may not see some of the documents, or they may be overwhelmed. They may not be listing through hundreds and hundreds of pages. Some of the asylum cases we file are like boxes of documents, thousands of pages. And the officer may not be interested or have time or patience to go through all those pages. So you want to organize, you want to highlight the important parts, you want to have table of contents and so on. To do all this, everybody can learn anything they want, right? You can build a house without hiring builders. If you learn everything, there is famously a woman on YouTube who learned everything on YouTube and built herself a house, right? It's possible, it's doable, it's not impossible. But is it a good idea? If it falls, then if your house falls apart, it's going to cost you a lot more. Now, similarly here, you are going through this asylum application process with the USCIS, on which your livelihood, your life, your future in the United States, generally the future of your family depends. So it's not a good idea to try to learn new things and make mistakes and then try to correct those mistakes down the road. It's best to hire a professional, work with an immigration lawyer. Asylum is not a simple process. You want to have an immigration lawyer who's handling it. We will be happy to help you, but you don't necessarily have to work with us. You can work with any immigration lawyer that you feel comfortable with. You can, schedule consultations, talk to them, see who you're feeling comfortable with, work with them. But I strongly encourage you, if you're filing for asylum or waiting for interview, expecting going through asylum process, do work with a professional. Do not work with an unlicensed attorney or paralegal or someone who is not licensed to practice law. That's similar to, undergoing a major medical surgery by someone who is not a licensed doctor. You probably wouldn't do that. Nobody would do that, unless they're crazy. So similarly here, you don't want to put your livelihood of your entire family or your own self under, somebody's advice who is not qualified to give that advice. If they didn't become a lawyer or get their license, there is a reason behind it, and that reason is going to hurt your case. Okay, so I went too deep answering this question, but just want to make sure that all of these points are heard. But the brief answer is do it as soon as possible, get everything well organized and file, supplement your case as soon as possible. Don't wait for the interview. The next question is, when did you get the bottom? Okay, that was question. The next question is from Melisa to the previous question follow-up. So the next question I have is, hello, hi everyone. Yes, hi. And Yurii says hi. Melisa says, I filed for asylum in May 2023, got receipt at end of May. Now, June 2023, I have to take biometrics. This is so fast. And does it happen that fast? Yes, it does happen that fast. Right now, the receipts are issued instantaneously because you file it online. All of the asylum applications can be filed online. It's a good idea to file only online, and you get the receipt and you have biometrics pretty soon. But that has no effect on your interview date. So all of that does go so fast, and that's normal. That has always been like this. The receipts have been delayed in mailed asylum applications. Now, for the last several months, since we have online filing, we never mail anything. We file again online, not just the application, but the entire asylum package with the documents and so on gets filed online. And that's the way you should do it. And once you do it, you get the receipt immediately soon. You get the biometrics notice soon, and the case goes forward. Now, the interview is another topic. The interview is chaotic. They can schedule your interview within 6 months, within 6 years. You never know. Currently, there is significant backlog. And one of the reasons why they transition to online filing, they hire more officers and so on, because they're working on trying to clear those backlogs. The previous administration did, Obama administration did, Trump administration tried. They messed it up even more by trying, but now Biden administration has been successful in reducing some of the backlog, improving the ways, but it's not guaranteed. So you never know when your interview is going to be, at least at this point. The next question I have is from Yurii. It says, are there requirements for the company which wants to sponsor EB2 or EB3? If a person opened the business and got W2 visa, can this company sponsor a relative, adult, married child for EB2 and 3? Well, there are several issues with your question, Yurii, because number one issue is that you're talking about the relative, adult, married child in the context of employment-based permanent residency. The answer is no. The way you put the question it sounds like somebody has a business, opens a business, and tries to help their relative or son to bring them to the US. That's specifically what is illegal, criminal to do in the context of employment-based immigration. And there are many people that get caught. We immigration lawyers hear lots of employers, individuals, and even immigration lawyers getting indicted under federal laws, and they are prosecuted under federal laws in federal courts, and some of them get imprisoned or they're significantly fined for trying to do this kind of thing, by trying to help their relatives by filing fake employment-based cases and so on. Now, I'm not saying that's what you're saying, but that's what the question sounds like, because you're talking about helping a relative through employment base. Now, if you have a relative or a friend or anyone, and you have a business here, it's a legitimate business, it's running normal business, and you do really need an employee, and you do demonstrate through the labor department processing that you couldn't find anybody in the US, and you go through certification, and this is a good faith job, good faith employment, and it happens to be that it's your relative or friend, and many employers hire their friends and relatives because these are the people they know the best, right? They trust the best. So there's nothing wrong with that just because they're relative or friend. It doesn't mean that you're committing fraud. So if you go all this through procedures in good faith, you do demonstrate you couldn't find someone, and you're sponsoring this employee, then yes, then it can work. The company needs to be a legitimate company. It has to be a good faith, legitimate business, meaning it's not just a skeleton of a business created for the purposes of circumventing or creating impression of a business, circumventing immigration laws. It's actually real business. If that's the case, then that business can sponsor an employee. One final requirement is, well, there are many requirements, but one of the requirements that is the major requirement, is that the business has to have either sufficient income or sufficient cash flow or sufficient reserves, or the owner of the business has to have sufficient money in the bank account to be able to pay the salary of the person who's being employed. If you're going through EB3 process or EB2 process, the first step will be for the Department of Labor to determine the minimum wage to be paid for that job. And that minimum wage, although it sounds like a federal minimum wage, that's not the same thing. This minimum wage amount means a median wage for this job in this area. So it can be substantial amount of money. As long as the business has that money, ability to pay that salary, then they can sponsor an employee or even multiple employees for that process. All right. So the second part of the question from Yurii is, if the child is in the US and waiting for initial asylum interview, so basically can someone who's waiting for the asylum interview go through EB2, EB3 process? The answer is yes. This is a very hot topic, and I believe, we've been having these live streams for several weeks now, and in every stream I get the same question on this topic, not from same person. But yes, so the answer is yes, it's possible. There are many different factors that affect whether it's possible or how possible it is. What are the chances? But it's possible. We have done this. We do this regularly. So going through the employment-based process, then we can obtain a advanced parole, allowing the beneficiary to leave the U.S. and return to the U.S. in case if the immigrant visa processing at the U.S. consulate fails. But usually, typically, it doesn't fail because we prepare well ahead and we have all of the information needed to know whether it's a provable case or not. So it's very much possible, but that's a type of the case that you want to consult individually with an immigration lawyer. And as I said, I can help you. I'll be happy to help you. I'll be happy to answer any questions you have. You can schedule a consultation with me or with anyone else. You're not limited. Thankfully, under the immigration laws now, the procedures now, you're not limited to lawyers in your area. You don't have to come and visit us in our office. You're welcome to. We have a beautiful office here in Fairfax at the outskirts of Washington, D.C., capital of the United States. But you don't have to. Everything is done online, everything remote, and even participations at the interviews and even in the individual hearings in immigration courts, participations at the USCIS office, asylum office, all of that can be done remotely via video conferencing, which significantly expands the options and horizon for you, the clients, who are not limited to the attorney next door, but you can hire anybody anywhere in the United States or even outside of the United States, as long as they're licensed attorneys, immigration attorneys, licensed in one of the United States, one of the states of United States of America. So again, that's important to verify that they're licensed. You cannot believe how many clients I get that contact me after the case is messed up because they worked with someone who was writing a story for them or preparing documents or even trying in good faith to help, but they didn't have immigration attorney license. They were not immigration attorneys, or they didn't have experience, or they had experience as a paralegal, but they were not licensed attorneys. They tried to do something on the side to help out and messed up. And there is not much that can be done after the damage is significant. You don't hear that much of these stories in public because those individuals who fall into these troubles after working with non-lawyers, they don't go around and tell everybody and brag about it. So that's why there is an impression that, some paralegal helps and somebody who writes stories helps people write their stories and every case gets approved. There is nobody who's getting caught. That's a wrong impression. A lot of people get caught. It's just those people who get caught or get into trouble, they don't brag about it. They don't tell anyone about it. So that's why, except us, immigration lawyers, because they come to us for help. So that's why there is this general impression that it doesn't happen, that, why would you spend money on a lawyer? You can hire somebody who's going to be, 5 times cheaper or so, which is usually not 5 times cheaper. But anyway, so don't do it, save your well-being, health, and, future of you in the United States with not doing that. Okay. So the next question I have is, so doing biometrics of asylum case, I'm going to ask any questions or they will take just my biometrics. No, as the name is biometrics, it's just the biometrics. There is no asylum officer. There are no questions at the biometrics appointment. It's just a standard process. It's a step. It's a technical step in asylum or any immigration procedures. That's one of the frequent questions I get. The question sounds simple and I could just briefly answer, no, you're not going to be asked any questions in the biometrics appointment. But also the importance of biometrics appointment is a little bit overhyped. I frequently, during consultations in the opening, the consultee often asks me, okay, I filed this on this date, I had biometrics on this date, how many days or months or years I have to wait after my biometrics, even like an adjustment of status case, marriage-based case, or so on. And I always tell them the biometrics is not the measurement. Biometrics is something, the fingerprinting appointment is just a technical step in the middle of the process. So usually the processing time calculation starts from, okay, my camera again started doing the weird thing. Let me try to zoom it in and out. Okay, so usually when we talk about processing times, we are talking about the date of filing until the date of either request for evidence or the date of decision, approval or denial of the case. So that's the processing time. The processing time begins from the date of filing, the filing date of your application, not the biometrics, not the day when you received the receipt, but the date which is on the filing date. So don't dwell on biometrics too much. Don't take it too seriously. The biometrics is just a technical step. In some cases, they don't even do biometrics nowadays. Since the pandemic, they've been waiving biometrics for cases where they have actually done already biometrics in the past. You may have applied for another benefit in the past, and then you'll get a notice saying, we don't need your biometrics, so we waived it. They do it so people don't get alarmed because people are putting too much importance and emphasis on biometrics unnecessarily. It's not as important. It is important that you have to go through it at one point for your case to continue moving forward, but it's not. And don't miss your biometrics. If you do, for example, in asylum case, if you file your asylum, Melisa, for example, in your case, you said you had biometrics. If you filed your asylum case, recently got biometrics notice, and you fail to appear, that will stop the clock for your EAD, for your employment authorization document. Because by missing the biometrics appointment or even rescheduling it, not just no-show, but also asking to reschedule, you are delaying your asylum case. So that's why, in the minds of the USCIS, because that's really not, technically you're not delaying anything because your asylum case will take years anyways, that there's a significant backlog. But in the perfect world, it would mean you would be delaying, because in a perfect world, the asylum interview would be scheduled within 45 days, which hasn't been happening for the last 15 years or more. So that's why they consider it as a delay caused by the applicant. So don't miss your biometrics. So in that sense, it's important to get the biometrics timely done, but don't, calculate your case from the date of biometrics or from lack of biometrics. All right. So biometrics of asylum, thank you for the detailed answer. Thank you for your question, Yurii. You're welcome. And next question is, hi, I lost my F1 status because I'm sick and could not go to school. What to do, please? Well, depends, how long ago you lost. There is a chance to reinstate your F1 status if you lost it for, reasons beyond your control. So depending on the timing of this, depending on the specifics, how sick you got, so there are possible ways to try to reinstate your status, or even try to apply for change of status, considering that if you were that sick that you couldn't, practically apply for a change or extension of your status or go to school, then you may be eligible. The USCIS has a power under the law to forgive missed deadlines if it was beyond your control. As you all know, they did that liberally during the pandemic. Many of the deadlines were missed or extended significantly. And even now, they are, we had a case recently where we sent the response to a request for evidence that the USCIS didn't register, and by the time we saw that the USCIS didn't register it, although it was filed timely, it was beyond the deadline for the RFE, and they didn't deny the case. That we've refiled it again, proving that we did file it before. It's just USCIS error, not processing. But the bottom line is, what I'm saying is that they're even liberal in all of these things. Still not the rules of the pandemic, the policies of the pandemic stopped. There is no automatic extension in the responses, or there is no automatic forgiveness of the gaps in status or violations of status that were during the pandemic. But now too, they're still liberal about it, because some of it was caused partially by pandemic, or by the COVID-19 pandemic, or something else. So anyway, so that there may be you may have a chance to reinstate or change your status. Consult with an immigration attorney individually, because there are lots of questions that I or any other immigration attorney would want to ask you before we can give you qualified advice. All right, the next question is, I want to apply for EB2 national interest waiver, but currently have a job offer outside the US, and I'm not to resume next month. If the petition gets approved, how do I get back into the United States? Just like if you were never in the US. So if you are outside of the US at the time when you get the petition approved, then you go through the consular processing through State Department. So your petition gets sent to the State Department National Visa Center, which asks for additional forms and documents. And then the NVC, once they have everything collected, they're satisfied that your case is qualified, then they will forward it to the US consulate in the country where you're going to be permanently residing at that time. So if you reside, in the country where you're going to be working at that time, then you will be able to go to US consulate over there and go through consular process, interview there. Now, at the interview, the consulate will either hold your case for review or approve or deny. If you're approved or held for review and then approved, they will give you 6 months of visa, immigrant visa. You have 6 months to enter the US. And once you enter the United States with that visa, which is going to be approved at the consulate, then you will receive your green card in the mail. So that's the process for somebody who's outside of the US. So for those who don't know what NIV stands for, National Interest Waiver, I will briefly explain. National Interest Waiver is a way for a talented individuals, or somebody whose work is in the US national interest, who have some exceptional skills. They don't have to be extraordinary. You don't have to be on top of the field of your endeavor, but you have to have something that differentiates you from others. And you have to demonstrate that your work in the US will benefit the US national interest. So this process enables that someone to sponsor themselves. You don't even have to have an employer who's filing a petition. It's a good idea to have an employer in the US to file the petition, but you don't have to. You can actually self-petition. So that national interest waiver process lets you to circumvent the labor certification process, which is traditionally everybody knows as EB3 process, right? The employment-based, where you have to go through the Department of Labor, your employer has to sponsor you, and so on. So national interest waiver is a very good way to get through this process faster. You have to demonstrate that whatever you do or whatever you will do, your proposed endeavor in the US, your work in the US, is of national importance. They also name it as has a substantial intrinsic merit, substantial merit in the US, such as, it's an important area. Most of the work in the US is within that important area. Unless, you're coming to the US to work as a cleaner, you can also argue that cleaning is a national importance in one way or another. I'm sure there are ways to argue that too. But anyway, so the second prong is that you have to demonstrate that you are well positioned to advance that field. That's where you demonstrate that you have exceptional skills, that you have these talents, or whatever you have done in the past has already achieved some goals in the benefit of the United States, benefited the US economy, welfare, well-being of the US, population, or generally benefited the United States as a nation. So That's the second prong. Again, exceptional skills, that you're well positioned to advance whatever the field of your job and work is. And the number three for national interest waiver is that you have to demonstrate that, assuming that there are other workers in this area, in this field, that having you as a foreign worker come to the US and take away that job from the potential US worker is going to, the benefit of having you is going to outweigh the problem of outplacing a US worker. So that's the third prong. So with that, a national interest waiver is a very good and, I would say, easy. It's not easy to prove, but it's easy because it's faster process to immigrate into the United States. We do frequently handle national interest waiver cases. We have great results. And if anybody wants to apply, to try, there is also a way to apply for permanent residency as someone who is talented, as what's called extraordinary ability. That's employment-based 1 category. Similar to national interest waiver, there is no wait time unless you're a citizen of certain countries which have limited quotas, such as India, Philippines, Mexico. So some of those countries, China, they have limited quotas for the national interest waiver for all of the employment-based categories. All right. So what news? Welcome, coro phase 2. I don't know what that means. Teddy Seyoum is asking. Next question from we is, how do you represent someone not in your state? I feel you won't be able to represent me effectively. Well, I would probably give weight to this question if it was before the pandemic. But if we went through pandemic, you probably know that's not true. So most of the immigration courts, all of the master hearings in immigration courts are remote and online. Many judges in individual hearings also prefer online. All of them allow online, even if they don't prefer it. The immigration offices, asylum offices, all of them are obligated to conduct interviews both in person and through video conferencing. So that has been the process for the last 3 years, right? Since the beginning of the pandemic, and it will stay permanently, the USA has announced. And I would say 99.9% of our cases we handle are all done online. There is no reason for immigrants, for individuals, for our clients to bother taking time from work, travel to our office. But you can, if you want to see me, you can see me just like you're seeing me now, right? If you want to, we're going to be on Zoom, right? If you want to see me. But a lot of people even choose to go through just phone consultation or phone discussions. We have emails, we have system where you upload all your documents. We upload all those documents to the immigration courts. Immigration courts do not allow physical filing anymore for all the cases since the 2021. Everything is done online. So in the 21st century, I see that you're able to use a computer to post a question, to watch this on YouTube, and I'm sure you will be able to handle, to communicate with your attorney also online, and to upload scanned documents, or even, use your cell phone to take photographs. So no, I do strongly encourage you to, open your horizon, get out of the box of in-person interaction. It's good still to in-person interact. There are some things where it's not replaceable, in-person interaction, but in terms of immigration law, you don't want to limit yourself to your local attorney. Now, again, I'm not trying to sell my business to you by answering this question. Generally, I do. That's, one of the purposes of having any kind of live stream, answering questions, spending all that time, is marketing, nothing to hide. But answering this question, I'm not trying to sell my business to you. I'm just being honest with you. Don't limit yourself to shaking hands with your immigration lawyer or even officer, USCIS officer, just because they're close to you. And so that, don't limit yourself to those lawyers. Hire somebody who you feel comfortable with, who you think is the most competent and experienced to handle your case. Okay. Next question is, another is the 150 days for the EAD is from fingerprint or the date send your asylum application. So Bkderos, I just explained to you, do not count anything from fingerprinting date. There is nothing, let me think about it. There's nothing that counts, none of these things. So instead of, me explaining, I'm not trying to be rude or abrupt in answering questions. I'm just letting you to be able to answer. You may have another 100 questions other than EAD or asylum interview and so on. The simple answer is anything that anytime there is a conversation about processing times, none of that starts from the biometrics, from the fingerprint. It starts from the filing date of their application. Okay, so next question is, can you go briefly on all steps of applying for asylum? No, I cannot go briefly. If it was brief, that would, we wouldn't have, years of video instructions that I've made. Just one video, which is brief instructions on evidence for asylum case. You can watch it on subscribe to our channel. And if you're not willing to do so, go to our channel and look at the videos, which was posted, I believe, a couple of weeks ago. I had one posted many years ago, and then I posted a new one a couple of weeks ago. That video is over 1 hour, and I'm talking about evidence for asylum case. And that is a very brief video for just that topic. So watch that video. It's going to be very helpful for you. And if you spend your time, which will probably take you days to review all our videos and instructions on asylum cases, which are, again, those are brief instructions. Those are compressed. So that will help you, on all steps for applying for asylum. Can you tell me how long, the same person asked, can you tell me how long it takes currently for each step, at least from your experience, from your customers? Thank you. Yeah, so from our clients, there is no consistency, not just our clients, but generally in the asylum case, how long they approve, how long it takes for the interviews or individual hearings in immigration court if the case is defensive in immigration court. The dates are chaotic. The interviews, dates, processing times are chaotic. The dates, what I mean by dates, I mean the dates in the calendars of the immigration judges are uncertain. There are new judges which have open calendars, so they can have a hearing for you within the next couple months, or there are judges which the earliest date is going to be in 3 years or more, the earliest available date. So, same with asylum officers. Some cases we file in rare circumstances. They schedule interview within 6 months or so, but most of the time it goes into that black hole, also known as backlog, and the backlog is uncertain. We have cases filed 7 years ago, which are still pending, waiting for the interview. We had some cases recently scheduled, which were filed 6 years ago, 5 years ago. I don't know how they're handling it. They don't know how they're handling it. We have a asylum division director meeting, I believe next week or so, where they will give us an update. We have quarterly meetings with the asylum office division director, asylum division director of USCIS, where they give us updates. So if they give us any, meaningful update on what to expect in terms of processing times, I will certainly make a video and post it. Even if they don't, I'll make a short video about that meeting with the division director to give everybody an update, but I wouldn't hold my breath. There is not much they know what's going on or they can do. I don't want to diminish the work they do. The asylum office, asylum division, the USCIS, they're working hard on getting these backlogs reduced, and they have succeeded in doing somewhat, some of it. But the things are, especially, with the processing at the southern border, they started, as you all know, with that CBP One app, which I strongly encourage everyone who is outside of the US, or if you have a relative friend who's outside of the US, you want to bring them quicker to the United States, and if they're eligible for asylum. I don't mean by abusing the system just to bring them here, because not just that, it's immoral, don't judge anybody, but also it's going to hurt that person, because by coming to the US through CBP1 app, they're not just going to be released into the US. Here you go, welcome. You don't need a visa. Enjoy, live here. No, they're going to be placed in removal proceedings in immigration court. So they will be in deportation proceedings. And the only chance they will have, at least at the time since they entered the US, is going to be applying for asylum. Now, there is a prosecutorial discretion, PD process, where they can potentially ask to dismiss their case down the road. But I don't think the government is going to entertain and dismiss the case, those requests for those who just entered for the purpose of asking prosecutorial discretion, unless they demonstrate that they in good faith had basis for asylum. So anyway, the government is improving, doing things to improve. They're doing well, but everything could have been done a lot better. I don't know. I'm not saying I have a solution, but it's not perfect. Okay, the next question. Thank you, sir. Thank you, Bello, for your question. What news updates? Welcome Corp Phase 2. Again, I have no idea what this means. It's the same person asking. Teddy, what does that mean? What news updates? Welcome Corp Phase 2. Oh, okay. That's so. I think you're asking about. Well, I don't know what's that name called. I don't deal with that process. I don't have news updates. That's for, I believe, Afghani and maybe some other country citizens who have helped the United States. So there is not much I have handled in that area, and we don't deal, and I don't believe there is much legal representation in that area. I may be wrong. So that's why I don't have an answer. I didn't even understand what you meant by Welcome Corp Phase 2. All right, the next question is, a friend's I-130 was approved just after 2 months. Does this mean that processing time has reduced? What about the processing time for I-730? No, it doesn't mean that I-130 processing time was reduced. We have hundreds and hundreds of I-130s pending at any given time, meaning current pending cases, and we don't see the 2 months approvals. We do once in a while, rarely. Actually, we had a very strange case, which took several weeks to get approved. And again, as I said, it's chaotic. There is no explanation, no reason why. We didn't even expedite that case. So, the US says, I don't know, maybe there's some kind of magic crack that the case falls into, as I sometimes imagine. They take all the cases and then a file accidentally gets dropped on the floor, and one officer picks it up and says, okay, I'll look at it. Or maybe they do a raffle. Maybe they have fun at the USCIS office. They decide to make someone lucky. I'm kidding. If there was something like this, that would have been a scandal. But you never know. There have been scandals in the US government enough. So that's what I'm imagining, because sometimes we have cases that proved within 2 weeks. Sometimes we have cases, pending for 2 years, and there is no explanation whatsoever. There are some cases which have delayed beyond normal processing because, either it was a marriage-based case for someone who previously filed for asylum, then the USCIS officer has to request the asylum file, or the consular processing. Some viewer asked previously about the EB3 process, for somebody who's waiting for asylum interview. Those cases are significantly delayed usually because the consulate was going to be handling the case, or even if you're eligible for adjustment of status, the USCIS officer, they have to request your entire file. Even if you withdraw your asylum case, it doesn't disappear. The fact that you filed previous applications with the government, explaining things or demonstrating, filing application, answering questions, that becomes permanent in your file. And that's one of the misunderstandings I often hear is somebody who filed for asylum waiting for the interview. They now either going through employment-based process, or they got married, or they now have 21-year-old child or so on who's sponsoring them. And they believe if they withdraw asylum case, everything magically disappears. In their asylum case, they wrote that they had, been arrested, charged with crimes in their country based on political reasons. Now they're filing the marriage-based case and they're saying, no, I've never been arrested, and so on. And that's how many of these individuals get in trouble. And the USCIS, what I was trying to say, must request and does request that entire file from the asylum office, even if you withdraw your asylum case. Again, I want to highlight this. Withdrawing asylum case, first of all, it's not a good idea until you get your green card or even after you get your green card. And withdrawing asylum case doesn't magically erase it from the memory or history of your immigration procedures or memory of the USCIS. You will be still questioned. If you withdrew your case and there were inconsistencies in that case between that case and your new case, marriage-based case, for example, it will be held against you, and you may end up being barred permanently from, well, not permanently, there are some waivers, but it's hard to get. Some of the waivers are not accessible. Or you may be found that you filed frivolous asylum application, which is a lot serious trouble you would get into. So, just so that you know. Now, what about processing time for I-730 PELA? The processing time is delayed. It's significantly backlogged, and it takes about 2 years or more. If there are emergency reasons, if you, for example, if you filed I-730 for your relative, and usually relative means children under 21 or spouse, and it's still pending, and there is danger to them, or there are any humanitarian urgent reasons, then you can file and request to expedite. The USCIS does expedite those. We have had success with expediting I-730s as long as we were able to demonstrate either significant economic issues that the family had, or danger, some kind of threats or issues that the family of the asylee had in their home country. That enabled us to expedite the processing by the USCIS and the processing by the State Department, by the consulate. So, but again, I wouldn't, even that is delayed because everybody applies for expedite. Not everybody, but there are so many expedite request applications now because of these backlogs. Everybody thinks that they qualify for expedite. They place the expedite request, and the USCIS has to consider every expedite request. Now the expedite requests are also backlogged. So, I jokingly tell my clients is that one day they will open an expedite request for expedite request, because expedite request used to take a couple of days. Now some expedite requests take weeks, if not months. We had an asylum case which we were able to expedite. The USCIS approved and said, yes, we will expedite it. And it's been going on for, I believe, more than 6 months now. And we send inquiries and they're saying, look, guys, we have too many cases which do qualify for expedite. That's why we approve those expedite requests. But now we have backlogged in the expedited cases because many asylum cases do qualify, because there are lots of individuals who are in the US. They have family members, close family members. They have urgent humanitarian reasons why their cases should be considered. And the government knows this, but they're trying to deal with this, and it doesn't work on every case. Sometimes they deny expedite requests on cases where it clearly should have been expedited. But again, the explanation to this is that they're now overwhelmed with expedite requests. So even expedite requests, unfortunately, are backlogged. So don't hold your breath on that. All right. Now, the final thing I wanted to say about the I-730 or delayed cases, whether it's asylum or, asylee family petition, there is one tool that you can utilize, which is filing a lawsuit against the USCIS or the State Department for not timely processing your case. And timely is a vague term. It has to be determined, depending on the case, what have you done, what was the basis, and so on. Not every case is the same, but you need to consult with, as I said, qualified immigration attorney. I'll be happy to consult you on this. But there is a process called mandamus action. It's a lawsuit filed in a federal court in the United States against one of the U.S. agencies, whether it's State Department or DHS or sub-agency, USCIS, where you can file an action in federal court claiming that they're not doing what they're mandated to do. And specifically, for example, in asylum cases, the USCIS has 45 days to schedule an interview, and then by the Code of Federal Regulations, the decision has to be rendered within 60 days from the time of your applying. They're violating the Code of Federal Regulations, the procedure that has been established by the government itself to process these cases. So by that, you can file a lawsuit against the federal government Is it a good idea to file in every case? No, the answer is no. Unfortunately, I know it sounds bad, but in some cases I have seen, at least in 2 cases, where the USCIS, once the lawsuit was filed, automatically denied asylum claim. I don't know what was their basis. Actually, I don't think they had basis to do that. But I told my client, look, we can, file a claim and another lawsuit against the USCIS. For doing that, just because you filed a lawsuit in federal court, they cannot retaliate or hurt you by just simply referring your case to immigration court without giving you an opportunity of the asylum interview. But that costs money and time, and you never know how it's going to end. So the client's priority was to get his case considered and approved as soon as possible, and rightfully so. I don't blame. I mean, I don't want these people to suffer as guinea pigs because we are trying to prove a point to the USCIS. So ended up, we got expedited his individual hearing, and we got approval in that one specific case. We got approval within 2 weeks. But basically, the judge agreed based on all that transpired. The USCIS so meanly, brutally retaliated by not even considering giving him opportunity for interview. The immigration judge was sympathetic to our motion to expedite and scheduled his individual hearing within 2 weeks from the master hearing. We didn't even have the master hearing. We filed a motion to waive the master hearing and asked to expedite, explaining what the USCIS did. I don't know who did it. Hopefully that USCIS officer or supervisor is no longer in business. It was during Trump administration, so not a surprise. But the judge granted the expedite for the individual hearing, scheduled the asylum individual hearing for this client within 2 weeks from the date when we filed the motion, but it was too optimistic. The DHS counsel, which is, so to speak, a prosecutor in the immigration court, they appeared on after 2 weeks to that individual hearing. We were fully prepared with an expert and so on, but they said we don't have the file yet. So they couldn't get the file from USCIS again because the USCIS was so much behind. I don't want to bash the USCIS. It was horrible during the Trump administration. A lot of these things were happening. So hopefully none of these individuals who were responsible for these things, files being lost, cases significantly mishandled. We had during the, I don't want to transfer this into political live stream, but I'm just talking about facts, okay, without judging. But during the previous administration, I mean, we work with the Department of Homeland Security, we work with Department of Labor, with the Department of State, all of these agencies. And the level of mishandling and chaos was just unbearable. We had green cards come to our office, green card that didn't belong. We had a client who had approved green card. I may be wrong. I think it was EAD the USCIS were supposed to approve, but they sent us a green card. Or they were losing things, files. They were sending wrong cases to us, cases that belong to the other individuals who we don't even represent. It was just ridiculous. Anyway, so hopefully it's getting better now, which it is between us. All right. So can someone? The next question is asked by High55. Can someone who is infertile woman can sponsor me from another country to USA? I don't know what infertility of the woman has anything to do with sponsoring you. If you're talking about can someone sponsor you for humanitarian reasons, the answer is yes. There is a process called humanitarian parole. It's the same process as coming through the southern border and using the CBP-1, but except in the humanitarian parole case, you wouldn't be, which is, it's also called humanitarian parole, but this one is filed with the USCIS. You wouldn't be placed in removal proceedings. The sponsor has to demonstrate that they're sponsoring you for a certain period of time until, whether it's for medical treatment, you're talking about infertility, maybe that's what you're talking about. Anyway, so I don't understand otherwise the question. I'm 19 years old. She's permanent resident. Okay, again, that doesn't give me anything, whether, how old you are. Next question is Dream MTJ says, hi, Ismail. Hi, Dream MTJ. Thank you for this format. What is the estimated time for interview for asylum cases? Dream TJ, if you go back to the beginning of this video, you will hear a lot that I talked about this actually right before this as well, answering this question. I believe I answered, but as I briefly, I'll tell you again that it's very chaotic. There is no specific timeline. There is no estimated time for interview for any asylum cases at this point. Next question is for Under Berbir. Hello again. Can asylee withdraw asylum case anytime after interview or before? Can she travel back to the country of origin after withdrawal? Please, your recommendations on the issue. Thank you, Sign. Thank you for the question on Berbir. And it's something I also explained in the beginning, or maybe you were already here. Withdrawing asylum case doesn't erase your case from history of your immigration. So if you filed asylum and then withdraw it, and then you go back to your country from where you were claiming persecution, then you have an explanation to make, right? So you have to provide an explanation down the road. You will be questioned unless the officer doesn't do their job, whoever is considering your green card, or when you're entering the US, or when you apply down the road for citizenship. This question may pop up, and it does pop up in many times, come up where the officers ask you, how come you filed for asylum, then you withdrew your asylum case because you got green card or some going through some other process, and now you went back to the country of your origin after withdrawal. What changed? You may as well have a good explanation. Maybe the country conditions changed. Maybe there was a revolution, the bad guy left, now you have a new government, things are better. Rarely happens, though, even after this type of revolution. It depends on the case you had. If the government was, specifically after you, now the government, Putin government is gone. Now you have a democratic government in Russia, which is, highly unlikely. Then, if you're a Russian citizen, I'm just giving you an example. Still, considering the level of volatility and the uncertainty, even with the new government, there may be a lot going on. The bottom line is it depends on your case, depends on your specific explanations. How come you were able to travel there even though you claimed you couldn't in the past? All right. Now, if you're saying withdrawing asylum case after the interview, you're asking also after the interview or before. After the interview, it depends. You may not be able to withdraw your asylum case after interview if your case is already decided and sent to immigration court. Now, also know that if you withdraw your asylum case from asylum office and you don't provide evidence that you're already permanent resident and so on, the asylum office will send your case to immigration court to removal proceedings, to deportation proceedings. Then you're going to have to close your case over there, which will be additional costs, money, legal fees, expenses, time that you're going to have to lose all that time. And you cannot travel. If your case is in immigration court in deportation proceedings and you travel outside of the US without closing your case, you may get an order of deportation. That is a big problem. Then you have to file a motion to reopen. You have a lot more trouble. So make sure you work those dates and times and when you withdraw. If you're withdrawing your case, it depends on what happened. Why are you withdrawing? So all of that will matter a lot. Again, going back to my previous conversation, this is a life-determining steps. Consult with an immigration attorney. Hire someone. Don't hire me. Hire someone. But don't just ask general questions, hoping for general answers, then piece together this to determine your future. Consult one-on-one with an immigration attorney. I'll be happy to help. You have links there to schedule it directly with me, or contact anybody else who's qualified. One of my colleagues, there are great immigration lawyers. Go to American Immigration Lawyers Association. There is an attorney search button where you can search for attorneys. If you do want, like our other viewer, if you don't trust online communications or telephone communications, you want to touch the attorney's hand, then find somebody who's local, but look at their reviews and background and information and do that. But don't do it on your own. Okay, next question from Omar. Please, I have talked to the US Embassy in Ankara. They said that I have to contact NVC. The natural visas, no, not natural. Now you confuse me. The National Visa Center. Visa Center, please, I need to know what time is my what? The question ends there. I'm waiting for interview. Okay, for 6 months now. All right, so I don't understand the question. So you are going through the process through NVC, probably immigrant visa processing, and you contacted you're expecting an interview at Ankara, Turkey, and you contacted the consulate, and the consulate said contact NVC, National Visa Center, to find out when is your interview. So you're asking what should you do within 6 months and so on. Without knowing all of the details of your case, I cannot give you the answer specific to your case. But generally, what it means is that either you have to first verify whether the National Visa Center confirmed, NVC confirmed, that they have all of the documents they require to send your case to the consulate, right? So NVC, for everybody who doesn't know, NVC is a State Department's department within State Department, which is called National Visa Center, which is an intermediary between the consulate and the USCIS. So anytime anyone goes through green card process, immigrant visa process, which ends with getting a green card, and anybody who's outside of the US goes through that process, then you have what? You have USCIS petition processing, right? That's filed in the US. That once that petition, whether it's from employer or family, once that gets approved, how does the case end up in the consulate? That's where NVC comes in. So NVC is a State Department's department which sends you an email, asks you for all the documents, tells you to file forms online. All of that needs to be uploaded. They process the case for the consulate, and once it's processed, they send your file to the consulate, and they tell the consulate, hey, we got everything in order. This guy has all the documents in order. He's ready for the interview. Then schedule this guy's interview, the applicant's interview. So, Omar, your case may be stuck at the NVC. Maybe the NVC didn't notify the consulate saying we have everything, or maybe they don't have everything. So you need to check first the status of your case at the NVC to make sure that it's documentarily qualified. That's what the NVC says. The case status has to say that everything is uploaded, all the documents they need has been uploaded, they verified everything is good, in good order, and complies with the requirements, and then they put the case status, and they actually send you an email saying your case is documentarily qualified, wait for the notice of the interview. Then the NVC sends the file to the consulate, and the consulate puts your case in the queue, in the line for the interview. Now, some consulates have faster, smaller, shorter lines. Some of them have backlogs. Consulate in Ciudad de Juarez, for example, in Mexico, you may have to wait for 1 year or so until you get your interview scheduled. Consulate in Philippines, in India, many of these consulates, we often have to try to expedite cases in those consulates because they're significantly backlogged. Now, some consulates in Europe, some consulates in other countries, not necessarily in Europe, but in Middle East, Asia, they don't have such a huge backlog. Now, we all often asked if there is a way to change between the consulates. The answer is it depends. So you cannot choose a consulate just because you want your case to be faster than everybody else. If you have a significant hardship from going to the country where your normal consulate would be, then you can ask for third country processing and so on. Then that can expedite your case, or you can ask to expedite your interview. Now, I see, Omar, you wrote that NVC already approved it. I don't think, okay, I guess what you mean is NVC said that it's documentarily qualified. It's not approval. So if the NVC confirms that it's documentarily qualified, then the issue is with the consulate, unless the consulate says, hey, we don't know, they didn't tell us that it's qualified, we don't have an interview scheduled for you. Now, there is NVC inquiry page. There's also NVC expedite site. If you just type NVC expedite, I don't remember exact email or the page link. If you type NVC expedite, if you have basis to expedite or just a complaint that it's been taking so long, there is no information, the consulate says they don't know, you can send them that inquiry and they will contact the consulate. They will try to sort it out. Now, NVC and the consulate, unfortunately, just like USCIS, they have been in backlogs, chaos, mishandling, bureaucracy. We have a case in which consulate is that? I mean, we have lots of cases pending with all the consulates, but this specific case was in Kinshasa, in Congo, and that consulate, it's been more than 6 months or so that has not been able to accept the documents which we have been trying to upload and email and so on. In the end, I sent a very nasty email and copied it to the deputy secretary for consular affairs and so on. I'm not saying that threat or that copying necessarily affected it, but I just basically demonstrated how upset we were with this delay or mishandling, because random people were answering us different way to each question, and so on. That helped. Anyway, the bottom line is, make noise, write emails, send inquiries, contact your senators, state senator, your congressman, your representative. Do your best to make as much noise. Keep emailing the consulates. I understand they're going to get back to you and say, oh, it's within normal processing times, but we have to put pressure on them. I mean, unfortunately, I don't want to create more chaos by giving this advice, more chaos on top of that what they have, but make noise. Now, if your case is within normal processing times, if you don't have any emergency, don't do it. Don't create any chaos. Don't make things matters worse. If you have an emergency, if you have reasons, I always tell my clients, sometimes I get contacted and say, oh, what's the processing time? I say it takes 1 year, for example, 8 months to 1 year, depending on the location, for the marriage-based adjustment of status case, right? And the client says, can I do something to make it faster? I tell them, look at it this way. You're at the airport, right? And you have 300,000 people in front of you in the line, right? Now, by telling everyone that you want your case faster than everybody else, you're basically at that airport. I bring example of airport because that's usually the longest and the most boring lines. So at that airport, you're telling everybody to move aside. You're basically yelling in that airport, everybody move aside. I need to go in first, right? So if you do that, you have to have strong reasons, explanations why you should be before everybody else. And if you don't, they'll probably punish you for creating this more chaos. Similarly, in your immigration cases, if you don't have emergency reasons, if you don't have reasons, something is burning, if you just want to join your family faster than everybody else and so on, please don't try to expedite your case, right? You can complain about the government generally processing times being so late. You can complain about the bureaucracy in the US government. You can, try to contribute to the solutions to find ways to improve the immigration procedures. You can write to senators, congressmen, and so on. But don't make matters worse by just because you want to be before everybody else. Just like everybody else says. I'm not saying this to you, Omar. Don't get offended. I'm not referring to your case. Absolutely not. I'm just giving example of those cases where somebody may be, trying to be before everybody else. Put it in that context as an example. At the airport, you're saying, everybody move aside. I need to go in first. The question is why? Not that it wouldn't happen, but everybody will want to know why. Or, the TSA at the airport will want you to provide good reasons why your case should go first. And similarly, this is what happens here with the USCIS. All right, I have some of the questions with the admin. I'll answer a couple of them as soon as possible. If anybody has any questions, please post. But I've been going on for now 1.5 hours almost. I will try to wrap it up in 7 minutes. So if you have any last call questions, please post. I will answer. Please also like this and subscribe to our channel. You will find a lot of useful instructions, news, and videos on our YouTube channel. Please subscribe so you will be notified. Please press that, what is that called? The bell sign, so you will be notified of all the new videos, and also you'll be notified of each time we have these live streams. And we have these live streams weekly on Thursdays at 12:30 p.m. Eastern Standard Time, which is Washington, D.C. time. Many go by New York time, which is same time. So 12:30 p.m. on Thursdays, join us on the live stream. I will answer any questions you have. Please also let your friends, relatives, somebody who maybe, sometimes you have somebody asking you a bunch of immigration questions just because you're in the United States. Tell them, hey, we have this immigration lawyer. Now, you decide how you want to describe me. A great immigration lawyer, a good immigration lawyer, that's your choice. I'm not going to be offended. So tell them, hey, he's providing this free advice on live sessions, 12:30, here's the link, join, and you can ask as many immigration questions you have, and I will do as much as I can to give you comprehensive and complete answer. So thank you very much, everybody, for joining. And please join us again. And thank you for listening, and have a nice rest of the week and the weekend ahead. Thank you very much. Bye-bye.